but it's a huge pleasure that we can greet you today at our forum with this extremely important topic. And Odessa's forum, it couldn't happen without your issue, the maritime disputes issue. It's not just mediation, also other opportunities to use for this kind of dispute resolution. I know that you are extremely experienced. Yuri is the head of the UA Maritime Law Committee. He's an arbitrator. He's a managing partner of UMAC committee, and he's the head of Sergeyev's law office. Today is the World Oceans Day, and the floor is yours. I'm extremely curious to listen to your panel to see how the disputes could be resolved and which practice exists worldwide. Thanks a lot to Luisa, to Ukrainian Academy of Mediation, for the suggestion to conduct this panel during this World Ocean Day. The topic is arbitration, mediation, or hybrid modern approaches to resolving maritime disputes. And our respected guests, I will briefly introduce them, and then we'll tell you again in more details who our respectful speakers are. George Lambrou, he's an international dispute resolution specialist. He's an attorney and arbitrator and International Arbitration Council. I will talk about George in more details later. Jonathan Lux is an international commercial mediator, arbitrator, and barrister accredited by the International Mediation Institute and the Civil Mediation Council. Thank you, Jonathan. Professor Andrea Lista, professor of maritime and commercial law, director of the Institute of Maritime Law, legal counsel of Southampton University, and also our colleague, lawyer, and advisor, Andrea. Nice to see you. And we also have among the speakers, Karina Horova, arbitrator of the International Commercial Arbitrage Court at the Ukrainian Chamber of Commerce and Industry, partner at Interlegal. Thank you, Karina. And again, I want to say that we had a common presentation together with Mykola Melnikov, partner at Interlegal and also deputy chairman and arbitrator of the Maritime Arbitration. And Mykola is now fighting against the aggressor. He is at war, and unfortunately, he will not be able to join us today because he's performing his military duties right now. That's why I suggest that our colleagues, you please stick to our agenda. We discussed it with you. If you need technical support, please don't hesitate. We will show your presentation, we'll demonstrate the slides and help you by all means. Dear participants, let's start. Let's start today from a very interesting presentation of George Lambrou. It is called Modern Trends in the Maritime Arbitration. George is a very famous solicitor of England and Wales, arbitrator, and he's densely connected with the maritime disputes, maritime arbitration. He represents the parties. He is either the head of the arbitration committee or an arbitrator himself, and he has a huge experience of participation in arbitration conducted in London, Athens, Istanbul. So the main cities in our arbitration sphere. Professional practice of Mr. Lambrou is very broadly represented in the maritime law, and of course, maritime arbitration is an important part of this. Before he joined Keystone Law in 2018, he was a partner of Thomas Cooper London law firm, and he is famous also for his work with the maritime disputes. He is also a co-director of education, and Chartered Institute of Arbitration. He is a member of London Maritime Arbitration Association, has a lot of other titles. It's too long and we are limited in time, so I will not read it further, but you can Google it. George, the floor is yours. Please feel free. And I wish you fruitful work during our session. Thank you for agreeing to present today.
Thank you very much, Yuri, for that very kind and generous introduction. First of all, I want to thank you because if it wasn't for you in organizing this session, it's very, very difficult to organize these things. And I'm very, very grateful for all of your hard work and diligence in getting this great team together. It's wonderful to share the tribunal with old colleagues and friends. I'm thankful for the opportunity. One thing I just wanted to ask about the slides. Now, will the slides be shown by the organizers? Yeah, okay. So we could start with the first slide then. And then the next slide, thank you. So before we talk about current trends, I thought it was important to give a little bit of a background of sort of big picture, start with the big picture. How do people around the world generally settle maritime disputes? And it's an oddity because maritime disputes take place clearly all over the world. This is an international business between international parties. They have disputes of all sorts taking place all over the world. So you would think that there would be many, many different places around the world where maritime disputes are resolved. But in fact, for historical reasons, the vast majority, I've heard figures of almost 90% of maritime arbitrations take place in London under the rules and terms of the London Maritime Arbitrators Association. So this is the context. And when we talk about maritime arbitration, because of the huge numbers taking place in London, this is why the emphasis is placed there. In 2025, the most recent statistics, there were an incredible 3,469 appointments, and these are estimated. Probably the numbers are higher than this. And for about 2,015 arbitration references, that's in 1 year. And out of those, the arbitrators made a total of 563 awards, of which 83 were made after an oral hearing. Now, let's compare that to references in other institutions or other centers around the world. If we could see the next slide, please. So historically, this is a summary of caseloads of very well-known arbitration institutions around the world. I want to emphasize these are not maritime cases. These are all cases. So we can see that although certainly by other measures, you might say that sort of the ICC in Paris or the LCIA or the SCC are great institutions, and there's no question. And they perform an amazing job, and they have very many high-value claims. But if you look at sheer number of appointments, then the London Maritime Arbitrators Association has by far a much greater number of appointments and a heavier caseload. So this sort of puts things in context in terms of when we're talking about maritime arbitration in London, what it is that we're talking about. Next slide, please. Now, this all sounds very impressive, and if you looked at these numbers, you would think that everything is resolved by arbitration. But if you look at a closer look at these numbers, then, and we analyze them just a little bit, then we'll see that based on those statistics, it looks like that if you had 2015 references, of which and you had only 563 awards, then you're talking about only 27% of the arbitrations which commenced ended up in award. So 73% did not end up with an award. So what happened to the 73%? Well, those were either amicably resolved by the parties in some way or not pursued further. They certainly did not end up in an award. Then we look at oral hearings. And we always imagine arbitration, there's this oral hearing. But here we only look at 4.1% actually proceeded to an oral hearing and an award. So the rest of them were based on the exchange of documents alone. So the conclusion you can reach from this is that the overwhelming number of disputes which were actually referred to arbitration end up being resolved outside of those arbitration proceedings in some way. And again, we're looking at London, which has by far the biggest caseload of any other city in the world. So this is a very good representation, and it also is consistent, and I'm sure my colleagues would agree with me, is consistent on my own personal experience based on many arbitrations. These numbers and these percentages seem to be consistent with what I also have experienced. The next slide, please. So what are we looking at here? How are these other cases being resolved? Well, the most common form of, let's call it a hybrid dispute resolution mechanism for maritime disputes currently, based on my personal experience, is a combination of arbitration, where arbitration commences, but then the parties engage in negotiation in the background in parallel to those arbitration proceedings. So very oftentimes you'll have cases resolved between the lawyers in the case, and they'll resolve it through one-to-one negotiations. Based on my own personal experience, the second most common form is a combination of arbitration and mediation. And this is a run in parallel. Sometimes you can have mediation before the arbitration commences, but because many times parties are concerned about time bar issues, and because it's so inexpensive to commence arbitration, it costs £400 to make the appointment fee. Parties many times will commence the arbitration and then move to mediation. But the mediation, as we know, can take place at any point throughout the dispute, either prior to the dispute or during the course of the dispute. Many other rarely used, although very effective, is something which we call expert determination, which is where the parties agree to refer the technical question to an expert and agree to ask that expert to resolve the dispute. And either the parties would agree to follow or agree just to take it under advisement, but not be strictly bound by that technical expert's determination. The important thing to remember is that in London, because it's a very conservative seat where parties, and because of the history of arbitration in London, parties feel uncomfortable adopting what we call med-arb or arb-med combinations, where you have the same person acting as an arbitrator and then acting as a mediator. This is extremely rare in my experience, certainly in maritime disputes in London. So whatever is happening in parallel to the arbitration, but on a without prejudice basis. And I think I just want to spend a minute talking about without prejudice, because it's often used in a way which people don't, it's misused. Without prejudice is a mechanism under English law, whereby a party can put forward a settlement offer, enter into negotiations, but anything which is exchanged during those negotiations or the mediation are strictly without prejudice to the arbitration proceedings, which means that it's prohibited from any information or document which is exchanged in those negotiations to then be produced before a tribunal. And the reason for that is to protect the ability of the parties to negotiate without having that count against them in the arbitration. So if I say, for example, in a mediation, let's say Jonathan is the mediator, and I say, we had a mediation, I offered 20%, the other side actually was ready to accept a certain amount in settlement. It means that they were admitted that they were wrong, and I'm going to produce this back to the arbitrators. That's strictly prohibited. And this is how these hybrid mechanisms, we call them hybrid mechanisms, but actually they're parallel, and nothing is inhibiting with the, let's say, sanctity of the arbitration proceeding itself, but lots of things can happen outside of those arbitration proceedings. Next slide, please. So what are the current trends? Well, the one current trend I notice is that there's a relative increase in the role of non-London-based lawyers representing clients in LMA arbitrations. Many lawyers, as we know, are coming from Ukraine, directly representing clients in London Maritime Arbitration, doing an excellent job in doing so. Many lawyers coming from Turkey and from many, many jurisdictions around the world are representing their clients before a London-based tribunal without instructing English solicitors for the full representation. So this is a trend, and as the skills of non-UK lawyers increase, as they're as they become more familiar with London Maritime Arbitration, they feel more comfortable representing their clients. And in my view, that's only a good thing. I'm saying that now as a London solicitor, but I do think it's a good thing because I think this helps bring down the costs. It brings a lot of advantages. And if it's done well, it can be a very effective way of representing a client where that lawyer is closer to the client and has a much better idea of how to represent that client from the ground. A second trend, as of course, everybody's talking about, but I just did want to point on some of the amplifications, is the use of AI. AI is being used. There's no denying that AI is being used. It's being widely used. It's going to continue to be widely used. And it's being used now for analysis by experts, preparation of submissions. But is it also used perhaps by clients looking for advice before they go to the lawyer to say, well, let's see what the AI is going to tell me about the merits of my case? It is certainly used to prepare advice by lawyers for their clients. Is it being used by the arbitrators? Are arbitrators perhaps using AI to help them draft some of their awards? Well, that certainly is the case. And there have been a lot of debates about what are the codes of conduct for this and whether this should be disclosed. We won't get into that now. I just want to point out that these are the trends. Final slide, please. Looking ahead. Well, looking ahead, my own personal view is that through the use of AI, those current trends will accelerate. So there's going to be even greater access to London arbitration by non-UK lawyers who will be using AI to prepare their submissions. There's going to be, I also believe that there's a high chance that there's going to be actually higher percentages of settlement. Why do I say that? Well, if both sides are, even before going to their lawyers, plugging in certain questions and documents and so forth, and getting similar answers into AI. There's a dispute, both sides are putting the same questions in with the same documents, they're getting very similar answers. It seems to me that the scope of their differences are going to perhaps decrease, and that is where we're going to have a greater role for mediation, perhaps, for other forms of dispute resolution to close that gap. There's also going to be less contractual disputes in terms of the wording of contracts. There's going to be less contractual disputes in terms of information as we have better information, better drafted contracts. There's certainly the potential for AI to reduce the amount of arbitration awards, but I think also increase the scope for mediation to play a role once the parties have accessed and received advice and information from their lawyers in a combination from AI. Happy to answer any of the questions, but those are quickly the points that I wanted to highlight. Thank you very much.
Thank you very much for this insightful presentation. Dear colleagues, should you have any questions now to George, he can answer these questions because we have in spare time. This is our last session, and I hope that organizers that if we need that, we can go a bit beyond the timing outlined for us. I mean, until 8 p.m. Kiev time. Dear participants, do you have any questions to George? Please.
George,
I can't see any questions for now, but maybe we will have them later on, and I will have a few questions related to your presentation. But let me ask them after the end of the panel. I will ask the questions to each of you. At this point, we say the word of thanks to George, and I hope you will be able to stay with us through the session. Is that correct? Thank you very much. And I'm giving the floor to the next speaker. And our next speaker is Jonathan Lux. He's an international commercial mediator, arbitrator, and he has a vast experience of 37 years. He used to work in major law firms and went all the way to the co-founder, and now he dedicated his time to the mediation. He is accredited at the International Mediation Institute and the Civil Mediation Council. He was acknowledged as one of the best lawyers in maritime law, and he has many other achievements, and I hope we're going to hear about today. And I'm giving the floor to Mr. Jonathan, and the topic is mediation and hybrid precision in maritime disputes, practical aspects and modern trends. Jonathan, over to you.
Yuri, thank you very much. I concur with the thanks to you and to the organizers expressed by George. If you could put up my extensive slideshow comprising just one slide, that would be appreciated. Do you have that? It's the next page, then it is maybe 2 pages. Great. Really, ladies and gentlemen, it's just so that you have in front of you the structure of my talk and will therefore have some idea where I am at any particular time, hopefully. So starting with the introduction, life was indeed simple when I was growing up. Court litigation and arbitration were the only things on the menu. And just for an idea of how things were at that time, or at least in the view of some, I would quote US Supreme Court Chief Justice Warren Burger, who said this in 1982, and I quote, "The existing judicial system is too costly, too painful, too destructive, too inefficient for a truly civilized people. Reliance on the adversarial process as the principal means of resolving conflicts is a mistake that must be corrected. For some disputes, trial will be the only means, but for many claims, trial by adversarial contest must in time go the way of the ancient trial by battle and blood. So said Chief Justice Warren Burger, as I say, in 1982. Now things are very different, with multiple ADR processes, of which mediation is by far the most popular, and various hybrids. Also, the world is changing, and not in a good direction. Of course, there were always climatic and political issues, but not on the scale of what we are now seeing. I reference in particular the recent COVID pandemic and today's world, where it's not fanciful to suggest that three overbearing dictators, Presidents Xi, Putin, and Trump, may be about to carve up the world into their respective spheres of dominion and control. Now, what do pandemics and overbearing leaders have in common? Well, I suggest they are disruptive, interfering significantly with the world trade, which is the lifeblood of our industry, and may make it impossible for one party to a commercial venture, through no fault of his own, to perform the contractual obligations which he reasonably took on just some short time before. Litigation and arbitration are rights-based systems, and rights are, of course, important. I certainly wouldn't disagree with the notion that the rule of law is the very underpinning of a free and democratic society. But will such a rights-based system keep world trade afloat when the threats we face and their impact on the contracts our clients conclude are quite literally incalculable? For example, remember the case of the Suez Canal closure quite some years ago, when the vessel had to sail more than twice the distance at more than twice the cost in order to perform the voyage charter contract. As I recall, the English court dismissed the argument that the contract was frustrated and that the owner was entitled to freight corresponding with the particulars of the voyage actually undertaken. It was held that mere financial hardship alone is not enough to frustrate a contract, and that the hapless shipowner would be held to his bargain at the contract freight which had been agreed. So the traditional legal arguments, frustration, force majeure, may quite literally drive one party into liquidation. Let me now move to my second heading, the shape of modern mediation. What does mediation have to offer in this changed world? Well, as we know, mediation is quite simply facilitated negotiation, where a third party, the mediator, assists the parties, often two parties, but maybe multi-party, to resolve their dispute. Its origins are ancient, and time doesn't permit me to go right back through history. But in the UK, that stretches at least as far back as the 15th century, when the parties would attend what were called love days, when the baron would assist the commoners in resolving their disputes. However, I think mediation of the sort we now practice in the UK has a much shorter history. Its birthplace is in the USA and no more than about 40, 50 years ago. That's perhaps no surprise, given that the twin evils of cost and delay in the litigation process are at their most acute in the USA, and an alternative had to be found. Again, as you will know, there are different schools of mediation, from the purely facilitative to the evaluative, with all shades in between. And then there is also what's called transformative mediation. The orthodox view, with which I concur, is that mediation should be facilitative. My standard mediation agreement provides that if the mediation has reached impasse, and if both parties so request, then I, as mediator, would give a non-binding view as to settlement level. In other words, this will only happen if the mediation has failed, and fortunately, most mediations are successful. Now, I'd be happy, but at the end, in response to questions, if it's of interest, to run through the typical procedure which would be adopted in a mediation in London. But again, time constraints, I will move on. In fact, there is no set procedure, and the mediator will work with the parties to devise the best procedure for the particular case. Counterintuitively, the rate of the success rate of mediation is very high, approaching 90%. I say counterintuitively because, of course, the mediator has no coercive powers at all, and either party is free to get up and walk out at any stage. The fact is that mediation seeks to achieve a mind shift, and most parties are happy to stay and see what can be achieved. Finally, under this heading, I just mentioned briefly two recent developments. One is local to England and Wales, and the second is global. In England, we have the very recent decision in the Churchill case, where it was held for the first time. That was a Court of Appeal decision, where it was held for the first time that the court has power to make an order compelling the parties to mediate, and the power to impose sanctions if one of the parties refuses. The global development I'd referred to is the Singapore Convention, Singapore Mediation Convention, providing for the international recognition and enforcement of mediation settlement agreements. Now, it's said that the New York Convention played a big part in putting international commercial arbitration in the #1 position for the resolution of international commercial disputes. If that's the case, then of course it's to be hoped that the Singapore Convention, which is modeled on the New York Convention, will do the same for mediation. I will next take headings 3 and 4 together, hybrids and some examples. We have as George indicated, moved on from the previous rather binary court or arbitration offerings to a rich tableau of ADR processes and the possibility to combine these. Whilst there are all sorts of possible combinations, the ones I will now address are ARB-MED and ARB-MED-ARB. I know that in some civil law countries, it's accepted that the same individual can act as both the mediator and arbitrator. This is not accepted in England, and in my view, for very good reason. After all, how can the neutral receive all the confidential information which is shared with a mediator and then close his or her mind to that when acting as the arbitrator? Let's look at an example of a hybrid process. In Singapore, which has been very resourceful in the mediation space, first SIAC, that's the Singapore International Arbitration Centre, and then SCMA, that's the Singapore Chamber of Maritime Arbitration, adopted a protocol where the party first starts arbitration, and then the arbitration is stayed, and the parties attempt mediation, generally under the SIMC, that's Singapore International Mediation Centre, rules. And then, if the mediation is unsuccessful, the parties can go back to the arbitrators to proceed to an award in the usual way. On the other hand, if the mediation is successful, and as I've said, most are, then the parties have the option to take the settlement agreement back to the arbitrators to make an award, and that award should then be enforceable under the New York Convention. I'm not a great fan of this for several reasons. Firstly, it can be something of a straitjacket in that the mediation takes place right at the beginning, whereas mediation may actually have better prospects if resorted to later, after several steps have been taken in the arbitration. Secondly, it's certainly a valuable feature to be able to convert the mediation settlement agreement into an arbitration award and then have the possibility of enforcement under the New York Convention. However, we now have the Singapore Mediation Convention, and therefore, in many cases, it will no longer be necessary to convert the settlement agreement into an award for the purpose of enforcement. Another example of a straitjacket approach is the multi-tier dispute resolution clauses, which are quite common in the maritime world. Most of the suite of BIMCO contracts contain such clauses, which typically provide sequentially for good faith negotiation, followed by mediation, followed by court or arbitration proceedings. In my view, it's useful to have more flexibility regarding the timing of each process, rather than having to conduct, for example, the mediation phase before being able to progress to the court or arbitration phase. All that said, resort to hybrid processes is increasing. Also, as I mentioned, the English courts now have power to order the parties to mediate or engage in another ADR process and to impose sanctions if one of the parties refuses. my next heading, some practical perspective and a real life story. As we know, the key distinguishing feature between arbitration and court on the one hand and mediation on the other hand is that the former, court and arbitration, focus entirely on legal positions, whereas mediation focuses on underlying interests. The best story I've heard illustrating this difference relates to an orange. But as we are a maritime gathering, let's make it a ship full of oranges. The claimants argue that the oranges are theirs, and the respondents argue the reverse. What could a judge or arbitrator do in this situation? Award the oranges to the claimants, award them to the respondents, divide them 50-50 or in some other proportions between the two parties, or perhaps in a corrupt jurisdiction, the judge or arbitrator may decide to keep the oranges. Well, of course, in this situation, the skilled mediator drills down and establishes that one party wants the fruit of the orange to make orange juice, and the other party wants the skin or rind of the orange to make marmalade. And lo and behold, the interests of the two parties can be accommodated out of one and the same consignment of oranges. Now, it's of course rare for parties' interests to align quite so neatly, but I think it is a clear illustration of the difference between positions on the one hand and interests on the other. Now for the case. It involved an aspartank boy charter party between the owners of a small fleet of tanker vessels and an oil major charterer for the carriage of a cargo of crude oil in the owner's vessel, the Chip London, from Jeddah to Rotterdam. The charter contained the customary lay-time clauses and the option for the charterer to cancel the charter should the vessel fail to arrive at the load port by the date and time stipulated. As we know, as maritime lawyers, it's not necessarily a simple matter to say precisely when the ship is to be treated as having arrived. In this case, the owners maintained that the ship had arrived at the load port prior to the cancelling date, but the charterers, on a falling freight market, it has to be said, alleged otherwise. So the charterers cancelled the charter and the owner was forced to refix his vessel at a substantial loss. The charter provided that London arbitration, in accordance with English law, was to apply, and the owners commenced arbitration proceedings to recover their losses. After claim and defence submissions had been served and documents exchanged in the arbitration was stayed so that mediation could take place. In the arbitration, ignoring any quantum issues, the result could be either that the ship had arrived, in which case the owner wins, or the ship had not arrived, in which case the owner loses. In the mediation, there are, of course, private caucus sessions, and the mediator established that owners were struggling to meet their running costs and needed to maximize the possibilities to employ their fleet. And secondly, that their mortgagee bank held a fleet mortgage and therefore could close down the owner's entire operation if there was a default on the loan. Then, in private caucus session with the charterers, it was established that the charterers had no issue with the owners or the vessel as such. They were motivated to cancel by the possibility to make considerable savings in a falling freight market, and they recognized the possibility that they might lose in the arbitration. Well, what then came out of the mediation? In fact, the original dispute was parked, and the owners and charterers entered into a new long-term agreement whereby the charterers gave owners first refusal for the carriage of charterers' cargoes between specified load and discharge ports at market freight. Now, this cost the charterers nothing, but was far more valuable to the owners than even winning their arbitration case in full and recovering the loss of freight plus interest and costs. It was therefore an outcome based entirely on the parties' best interests, and it was an outcome which no judge or arbitrator would have had any power to order. My final heading is conclusions and hopefully interactive discussion. My conclusion can be put shortly, and it is that mediation, combined sometimes with other processes, is a force for good. Would anyone disagree? Thank you.
Джонатан, щиро дякуємо вам за те, що ви
Thanks
поділилися
a
вашим
lot,
досвідом з
Jonathan,
нами. І
for your
сподіваюся, що
experience.
також, як і
Thank
ви
you
в
for
слайді
sharing.
в останньому
In
пункті,
the
що у нас буде
last
плідна
point of your
дискусія,
slide,
інтерактивна з
I also
нашими
hope that
слухачами,
we
з
have
нашими
an
учасниками.
interactive
Якщо є питання, то, будь
discussion.
ласка,
If you have
можете їх
questions,
задати.
please.
Тут бачу, з'явилося питання
I
Джорджу. Чи
already
є
see
зараз
one
питання до
in the
Джонатана? Будь ласка.
chat to George. Do you have now currently questions to Jonathan?
Jonathan, чи зможете ви бути з нами по
Jonathan,
завершенню нашого
are you
панелі?
able to stay with us until the end of our panel?
Yes, Yuri, I should ideally leave at to get to another appointment at 6 p.m. London time, but that gives us about 40 minutes. Is that okay?
Добре, дякую. Сподіваюся, так.
Yes, thank you. We hope
Проте,
that
якщо є
yes.
питання до
But
Джонатана
if you
зараз,
have
будь ласка,
questions to Jonathan now,
готовий їх
please,
вислухати. І
we are ready
поки
to
Джонатан має
hear
можливість
them.
бути з нами,
And Jonathan
користуйтеся
is
цією
able to
нагодою,
be
будь
with
ласка.
us
Мабуть,
the
тоді
next 40
давайте
minutes. Please use it.
перед тим, як надамо слово
But
для
before
виступу
we
Андрея
give
Ліста,
the
нашому
floor
шановному
to
колезі,
Andrea
до
Lista,
всіх
we will
питання, до наших всіх спікерів
probably
сьогодні,
ask all our
які гібридні
speakers
процедури
now,
сьогодні
what are the
утилізують, на
hybrid
вашу думку, найбільш
procedures which,
ефективні у сфері морських спорів? Які
up to
саме
your
гібридні
opinion,
процедури?
are the most
Ви
efficient?
згадували вже
Which
процедуру,
hybrid
яка діє в Сінгапурській
procedure
палаті
do you
морського
consider the
арбітражу.
most
Мабуть, у
efficient?
вас
You
або у
mentioned
колег є ще думки з
Singapore's
цього приводу. Будь
procedure.
ласка.
Probably you or your colleagues have another point of view or additional information in this regard.
Найбільш ефективну процедуру гібридну,
The
ви яку
most,
вважаєте?
the most efficient.
So, may I venture a comment? I have suggested that flexibility is the watchword, is the important element. And I have suggested in an article a few years back that arbitrators, London arbitrators, have the power to order parties to mediate and to impose cost sanctions if they fail to do so. Now, I know that is a somewhat controversial suggestion, but it's one that I do hold based on provisions in the English Arbitration Act. So I think the most efficient hybrid is if the backdrop is arbitration. I've already said if the backdrop is court proceedings, the courts can definitely now can definitely now order parties to mediate. But if the backdrop is arbitration, then of course there is nothing to stop the parties at any stage from agreeing that they will ask the arbitrators to stay the arbitration for a sufficient period for a mediation to take place. Or alternatively, for those who endorse my view that the arbitrators have power to order this, the arbitrators themselves could stay the arbitration to enable mediation to happen. So that in that way, there is flexibility as to the timing of the mediation.
Зрозуміло. Джонатан, Джордж, ваша думка з
Thank
цього
you.
приводу?
I understand. Probably, George, you also have an opinion on this, the most efficient hybrid procedures in the maritime disputes.
Yeah, I mean, my opinion is going to be the most common opinion that you hear from every lawyer, which is it depends. It depends on the case. It depends on the people involved. It depends on so many different factors. And that's why I completely agree with what Jonathan said about flexibility. I think that's what's important, is that there's flexibility, both, first of all, in the legal representative, to be aware of and be educated and to know that there's more than just one path to follow. And this is critical, and this is why forums like this are so important, and to educate people around the world that there are these different options available to you, and this is what we are constantly working on. But it absolutely depends on so many different factors that I could not point to one particular system and say this is the most efficient one.
Зрозуміло, Джордж. Дякую. Тут з'явилося питання.
Thank you. I understand too. There is a question. What do you think?
Як може бути
How
вирішено спор
can
за
the
допомогою
dispute be
медіації
resolved with the help of mediation
вирогідному корпоративному компоненті
in a
в українських
corporate
судах?
component
Це питання задамо
with the
тим, хто
Ukrainian
практикує в
vessels?
Україні.
Probably we will
І
better
якщо
ask this
питань
question to
безпосередньо до
those who
Джонатана
practice in
зараз
Ukraine.
немає, то давайте
And if you
дамо
don't have
можливість
particular
виступити
questions to
наступному
Jonathan,
нашому
let's
доповідачу.
invite
Ще раз
our next speaker.
подякуємо Джонатану та
Let's
Джорджу
say
за
thanks
відповіді.
again to
І
George
хто
and
зможе
Jonathan,
залишитися до завершення
and
нашої
those who
панельної
can stay
дискусії, ми
until
ще
the
обов'язково
end of our
продовжимо
panel
відповідати
discussion. We
на
will
ваші
continue
запитання.
answering your questions.
Could I just answer the question, the
Yeah,
one you just posed, just because I have a real life experience of this, and just to answer your question exactly. So
Так, будь ласка,
last
звісно.
last year I was acting for the owner of a vessel which was trapped in Mariupol during the Russian invasion. The vessel was expropriated, and the crew were taken as prisoners of war. They were then exchanged, they went home, but the vessel still remains now out of the owner's control. And we had a big dispute with the underwriters of this vessel to seek compensation for the loss of the vessel. And this dispute was resolved eventually through amicable negotiations, face-to-face negotiations, and not through court processes or through arbitration. So even in these extreme cases, we can see that alternative forms of dispute resolution are actually working to achieve a result where the owner received compensation.
Щиро дякую, що поділилися прикладом.
Thanks again
І
for this
йдемо ми
example.
далі за нашою
We
програмою
will
нашої панелі.
move
Хочу з
forward,
задоволенням
and I
надати
want
зараз слово
to
і
give the
представити
floor
професора Андрея
and
Ліста. Мені
introduce
особливо це
Professor
приємно,
Andrea
враховуючи, що я
Lista.
також як ідея поєднує
It's my
викладацьку
honor
діяльність та діяльність
to
адвоката.
present
Професор Андрій
Andrea,
Ліста –
introduce
це
Andrea,
професор
because I
морського та
also
комерційного права, директор
combine
Інституту морського
educational
права при школі
activity
права
and
університету
legal
Саутгемптона.
activity.
Його наукова та
Andrea
професійна
Lista is a
спеціалізація
professor of
охоплює
Maritime and
морське
Commercial
право,
Law,
міжнародну право і
director of the
міжнародне
Institute of
комерційне право.
Maritime Law,
Він
legal
активно
counsel
займається юридичним
at
консультуванням
LMAA,
і в
supporting
різні
member,
професійні етапи своєї
and
професійної
he's
діяльності
actively
виступав консультантом
involved
Європейської
as
комісії
a
та Європейського
consultant of
парламенту. Та
European
також,
Committee
як і
and
наші
European
інші шановні
Parliament, as well
спікери,
as
має
our
велику
other
кількість інших
respectful
нагород та відзнак. І, Андрея, я з
speakers.
задоволенням
He has a
надаю
lot
вам
of
слово.
awards,
Дуже цікава також
and
доповідь. І
it's
я
my pleasure
бачив
to give the
кількість
floor to
слайдів,
you.
і з
I
нею
saw
також і
your
15, і
slides.
вони
I know that
такі
you have
об'ємні.
15 slides, and
Дуже вас
the
прошу
volume
не
of slides
обмежувати
is
себе,
quite
проте
big.
пам'ятати про
Please
наш
don't
таймінг.
limit
І тема
yourself,
у
but
нас про
remember about
правові
our timing.
застереження про вирішення
And
спорів у морських контрактах, практичні
please
питання
stick
виконання
to
і сучасні виклики. Будь
the
ласка,
timing.
Андрея,
And
вам
the
слово.
topics is mostly about the challenges of modern maritime contracts. The floor is yours.
Thank you very much, Yuri, for this introduction, of which I didn't understand a single word because I think I lost the translation into English. But I think it was a great introduction in any case. Ladies and gentlemen, around 70% of charter parties now contain hybrid multi-tier clauses, which provides for mediation and arbitration. So the question is, what happens in case a party bypasses mediation and commences arbitral proceedings instead? And that is what I would like to answer, the question I would like to answer with you today. But first of all, I would like to thank very much both Yuri and Luisa for their kind invitation. It's an honor and a privilege to be here in front of a distinguished audience and illustrious speakers. So I'm very, very pleased and honored to be here with you. So if you could please share my presentation, I would try to go through my slides as quick as possible, so as to then have a chance to discuss with you together some views on enforcement of mediation clauses with some hope you will find interesting observation. Thank you very much. We can go to the next slide, please. Right. So what I wanted to do is to discuss with you the enforcement of mediation clauses. If you're going to be so kind as to follow me for the next 15 minutes or so. From, first of all, a general perspective and from the maritime practice perspective, why this twofold approach? Because I noticed, both in my personal research, but also in practice, that there's quite a striking difference between how mediation clauses are structured in international commercial contracts overall and in maritime practice. So we can go to the next slide, please. And the next slide. So we're starting with the general commercial practice. So I just wanted to show you very briefly a couple of mediation rules which are not designed for maritime contracts. One is the Vienna mediation rules, the standard clause 0.7, which tells us that in the first place, in case a dispute arises, you need to refer the dispute to mediation, and then if it has not been resolved by mediation within a specific time limit, then you will need to go to arbitration. The next slide, please. Within the same vein, we have the ICC standard mediation clause, version D, and actually I was involved in an ICC mediation a month ago, and the structure is also very clear. So the parties shall first refer the dispute to the mediation via the ICC, and then if after a certain amount of days the mediation doesn't achieve the result which intends to achieve, then you move on to arbitration. And as we shall discover, ladies and gentlemen, this is quite different compared to the standard BIMCO multi-tier clauses, MED-ARB clauses. And this is something that it was mentioned before, both by George and by Jonathan, so of the possibility of commencing mediation after you start arbitral proceedings. And that actually creates a situation which is a bit different in terms of how we then face in practice a possible breach of a mediation clause. Next slide, please. So two questions. If we freeze here and we're talking about these two mediation clauses, the ICC and the Vienna one, they are structured in a very precise way, in the sense that it's very clear that first you go to mediation, and then after that you go to arbitration. So if we have an hybrid clause which is structured in this way, giving precedence to mediation first, and then after you go to arbitration, there are two questions that we need to ask ourselves in terms of enforcement. So first of all, how does this create a contractual obligation? So is mediation a condition precedent which you need to fulfill in order to proceed then to arbitration? And are you going to be in breach of contract if you don't go for mediation, you bypass mediation and you go straight to arbitration? Procedurally is another important question, is what is going to happen then if in case someone bypasses the ICC mediation clause and goes straight for arbitration? Is it a jurisdictional matter for the arbitral tribunal to decide, or is just a matter of admissibility? This is a very, very important distinction, ladies and gentlemen, because if it is a jurisdictional matter, then it's something that you can challenge also at a little level in terms of a challenge under the Arbitration Act 1996 as amended by the 2025 Amendment Act here in the UK, or at the level of under Article 5 of the New York Convention on Recognition and Enforcement of Arbitral Awards. Whereas if it is a matter of admissibility, then you can't have that. The decision of the arbitral tribunal is final, and you're not going to have recourse to grounds of appeals, both before a court of law and then at the enforcement level, at the enforcement stage through the New York Convention. Next slide, please. So this matters because of what I just said in terms of grounds for possible future appeals. Because if it's a matter of jurisdiction, I repeat, then you can challenge the jurisdiction of the arbitral tribunal at a later stage. If it's a matter of admissibility, instead, the decision of the arbitral tribunal is going to be final. Also, time bars are also very important. So, for instance, I'll give you an example of Danish law. On a general level, mediation attempts can suspend the time bar, but they're not going to be able to break the time bar. So the time is kicking, and that might be an incentive to bypass mediation and to go for arbitration. Next slide, please. So to answer the question of whether the breach of a mediation clause is a matter of admissibility or of a jurisdictional matter, there's consensus on Anglo-American law, but also Singaporean law. And I mentioned also there's a Dutch Supreme Court decision here in front of you. I'm not going to go into the details of that. What I just want to say is that the general consensus on jurisprudence level is that we are talking about a matter of admissibility, not of jurisdiction. Next slide, please. Now, going on to maritime commercial disputes, we can go straight on to two examples of BIMCO multi-tier clauses, mediation arbitration clauses. So we can go to the next slide, please. So the first one is the 2002 clause, and in essence creates this possibility, this hybrid mediation arbitration clause. And you can see that the idea is either party may at any time refer the dispute on to mediation. And this actually calls into question what Jonathan was saying before, and I totally agree with him that at that point, through the agreement of the parties, the arbitrators should have the power to suspend the arbitral process and to enable parties to go on for mediation. Next slide, please. And again, basically, the idea is the intersection here between the mediation process and the arbitral process, the arbitral procedure, is in essence that the arbitral tribunal may take the mediation timetable into account in order then to fit everything in with the timetable of the arbitral process on its own. The next slide, please. Now we go on to the 2021 BIMCO mediation alternative dispute resolution clause. And again, the idea is at any point of the dispute, there's the possibility to refer the question on to mediation. And then there are some procedural steps to be undertaken as a consequence to that. The next slide, please. And again, it's important, I just wanted to emphasize again, and this is what also George was pointing out in his talk before, that it's not unusual to start mediation after the arbitral process is already in place. So that is basically something that, and this is actually quite interesting in my view, because it is this is not something that I found in international commercial contracts on a general level. This is perhaps a little bit, you might find it a situation, similar scenario also in this kind of contrast, but this is kind of interesting for a maritime law perspective. The next slide, please. So now the key issues, and then I'm going to wrap everything up. So the idea is, in essence, in terms of enforcement of a mediation clause or an hybrid clause, which provides for mediation and then arbitration. First of all, it depends entirely on how the clause is structured, because if you have a situation like the Vienna mediation rules or the ICC rules, where from the language is quite clear that there is a condition precedent, that there is an obligation to go for mediation first and then to move on for arbitration, then you have a more emphasis, I would say, on the possibility of enforcing it legally as a condition precedent. Whereas I would say that if you have a wording which is vague and in terms of how the mediation clause is structured and the possibility to commence it also after the arbitration proceedings started, then it's a bit of a different animal in that regard. And I would say that the idea is there's also general perception. I think perception is very important in terms of how people have a perception of mediation in terms of, because you can see many clients, and I think it's really an experience that is common to many of us. there's a dispute arising. First, they try to reach a settlement, and then they say, okay, well, we couldn't find a settlement. Why do we need to go for mediation? We already started our own mediation, which is a very, very different proposition from mediation, actually. And more often than not, the presence of an expert mediator is going to make a difference. You know, someone as illustrious as Jonathan, for instance, in my experience, will make a big difference. But this is not the perception that many clients have. And so hence the idea of then, okay, let's go for arbitration and let's disregard mediation. We already started the mediation inter nos. So that is the idea. So how do you bypass all of this? Well, the drafting then phase is going to become crucial in that regard, and you will need to be very precise and very specific in the drafting. The next slide, please. And this is the last slide of my talk. So again, the importance of drafting in terms of then, if you want really to enforce it, the idea is if you clearly define what comes first and what comes next, and that there is a clear obligation to go for mediation, then in terms of enforcement, things become a little bit different compared to a broadly drafted mediation clause. And there's two cases there which are non-maritime law cases, the Channel Tunnel and the cable wireless. In the Channel Tunnel, what happened was there was a mediation and arbitration clause. And what happened was that one party breached the mediation clause and started arbitration instead, and the other party started a legal action before a court of law. And basically what the court told us here is that if you have a mediation and arbitration clause and someone bypasses the mediation clause, that doesn't entitle you to go to court. You need to go to arbitration, of course. And what is interesting instead is the cable and wireless case. And this, again, links very well to the last observations that Jonathan made in his talk before. And it is the idea that if there is a mediation clause and then you don't have arbitration, but you have a mediation clause and then you have jurisdiction before a court of law, then the court of law will definitely in the UK mandate mediation. But there are elements here which are of public policy value, in my view, in a sense that you try, of course, as a court of law to try to avoid, the overbearing number of cases, and you're going to basically mandate the parties and order the parties to go for mediation instead. Right, so ladies and gentlemen, so this is all that I wanted to discuss with you, but I find quite interesting that there is a bit of a difference between the maritime world, the maritime contracts, especially charter parties and other international commercial contracts. But I think there's quite a lot to be learned by this. And I also think that what George said before in his talk is really relevant, that artificial intelligence is really having a huge impact, will have a huge impact on all of this. And also, in my view, it will render mediation more prominent in the future. So, ladies and gentlemen, I shall not aggravate you any further. And like I once said on an English radio, if you have been, thank you for listening. Thank you very much.
Щиро дякуємо, Андреа, за
Thank you
ваш
very
виступ.
much, Andrea, for your presentation. Thank you for these insightful slides and the links for very specific forums, some references. Can you hear me in English? Can you hear interpretation?
Є переклад.
Yes, now I can. Thank you.
Чудово, чудово. Чудово. Скажіть, будь
Excellent.
ласка, ось стосовно застережень щодо
And
медіації, які
regarding
застосовуються в морських
this
контрактах, як
mediation
до
clauses in the maritime contracts, what is the attitude of the parties?
базові
Are they
типові
ready to include these clauses in the contract in 2026 and on, given certain experience of their application? Let's say it's been for 5 years now. What about the parties? Are they ready to apply these clauses? If not, why so?
Yes, I mean, we've seen that. We did a bit of of a research project on this with the Institute of Maritime Law, and we were able to survey a certain amount of charter parties. And we did see that they are very common nowadays. So there is a predisposition to that. Now, in terms of then how things are shifting, I think again, I'll just reemphasize what George said. The fact that many parties nowadays are using artificial intelligence and feed in their questions on to once the dispute arises, and that really shifts things on towards mediation. So there's going to be a big change in relation to that. So I would say that in order to answer your question, Yuri, they are very common now. So, and that is a fact. They will become much more prominent because of the role of AI in the near future, for sure. In terms of then of enforceability, I wouldn't see it as an issue anymore, in a sense that it's more to the advantage of the parties rather than an issue of enforceability at that stage, at that point. So it is more the idea of, again, what is very important is the perception of how people are starting to perceive all of these, and the perception of mediation as an effective alternative dispute resolution mechanism, more effective even compared to the past. It's going to be very important. It's going to make a huge difference in my view.
Дякую, Андреа.
Thank you, Andrea.
Враховуючи там останній мій досвід,
Given my recent
читав
experience,
документи, які були
I've read
створені
various
колегами з
documents
застосуванням штучного інтелекту.
drafted
На
by
жаль,
my colleagues
багато
using
так званих
AI, and
апеляційних
unfortunately,
апеляційних
there are lots of
документах так вони
hallucinations in
пов'язані
those
з застосуванням
documents,
практики
and they're
відомої сліди.
associated with
Що ми будемо з вами
practices
робити,
that
якщо
don't
ми
even
будемо
exist? What are we
зустрічатися
gonna do
всередині
if we
в комерційних
encounter the
контрактах,
clauses
морських
and the
контрактах,
commercial
які створені за
maritime
допомогою
contracts
штучного інтелекту,
drafted
за якими
with
навряд чи
AI,
можна буде
and
застосувати процедуру арбітражу
you
або
won't be
медіації
able
для
to
будь-кого
apply
в такому випадку. Це питання, мабуть,
arbitrary or
більше
mediation
до Андрея,
procedures.
до
What shall we
Джонатана.
do? It's not the question not only to Andrea, but also
Якщо
to
будуть
George and
створені штучним
Jonathan.
інтелектом
If
контракти,
AI
які будуть
creates
застереження,
contracts
які не
that has
відповідають
that have
текстовим чи
clauses
запропонованим в
that
або
do
іншим
not
на вашу думку, як це
meet
складається?
IMCO requirements, the requirements of other institutions, what shall we do?
Сподіваюся, було чутно питання, так?
I hope you heard the question.
Could you please repeat it one more time, just to make sure I understood it?
Так, без проблем. Я маю на увазі, що якщо ми зараз багато говоримо про штучний
Today
інтелект,
we're speaking about AI at length, and we can see in practice that those who use it to draft the contracts, they apply the Supreme Court practices in Ukraine that does not even exist. They do not verify the facts and submit the documents to the courts. And we will increasingly encounter the situations when people draft the contracts without using standard BIMCO formats, and that is going to have the clause that are going to apply the mediations of these other institutions, but they won't comply with the real practices. Will we be able to use this practice then?
Well, if I might, just I like to compare. My impression of AI is that it's something like Google Maps. You know, when I was getting in a taxi and Google Maps first appeared, there were many taxi drivers who said, Google Maps, so unreliable. There's no way. I know the best way. And many times they did. And many times the maps made mistakes. But increasingly, as the years go by, I think we can all agree that every driver is using Google Maps. It's extremely reliable. I'm not saying there's never any mistakes, but has improved hugely. At the end of the day, the driver is responsible for getting you to your destination in the same way that the lawyer is responsible for everything which is put in the contract. And we had a recent case in England where a lawyer presented a case to the judge, which included some hallucinations, some cases which did not exist. He blamed it on AI, and the judge imposed very, very severe penalties on this lawyer as an individual lawyer, a huge fine, because the message was, this is no excuse. You have come to this court, you've misled the court, and there will be, as a solicitor, an officer of the court, you will face very, very severe consequences for misleading the court. It doesn't matter why you misled the court or how you misled the court. The bigger picture is that when we come to drafting contracts, as AI improves, I think it's going to be much better than many non-lawyers drafting, commercial people where English is not their first language, brokers and various people cutting and pasting clauses which are inconsistent with each other. This is actually what's happening now. So it's hard to believe that things are going to get worse.
Well,
And probably with time they'll get better.
I would just add this, that
Так,
the
Джонатан,
English,
будь ласка, дякую, Джордж.
the
Thank you
English
very
court,
much, George. Mhm.
the English courts approach issues of construction with expressly in mind that their role is to make sense and not nonsense of the contract, if they can. But if there is something included because the AI drafter has hallucinated, then the question might be, can you demonstrate, can the parties or the party who wants the contract enforced in a certain way, can he make out that there was in fact a common intention as regards the particular provision? And if there was a common intention, then the contract may be rectified so as to reflect that common intention. But it's undoubtedly causing a great difficulty, and therefore lawyers may be saving a lot of time using AI, but they should be using at least some of the time they spared in checking the output of the AI system they're using.
Щиро дякую, колеги, щиро дякую,
Thank you very
Джонатан.
much, dear colleagues. Thank you very much, Jonathan. We have the resolution of the Supreme Court that says that the application of AI by lawyers without the verification can be seen as disrespect to the court. And I can see that Arno Kupin wants to ask the question. If you can unmute yourself, dear tech support, could you please enable the person to unmute himself? And I can see there are other questions on the chat that are quite of general nature that do not relate to the presentations. So we will answer them after we hear the last speaker of today. I hope that we will be able to give the floor to Arnold. Further, I'm giving the floor to Karina Horova. She is an attorney and the partner of Interleague commercial firm, and she's deputy chairman in arbitration, maritime arbitration, and her professional activity is the participation of various maritime disputes at various levels in various jurisdictions. And she's arbitrator of the ICAC, and the topic is the changes and the procedural moderation, adaptation to the international arbitration standards, and other. Karina, over to you. Dear colleagues, I hope you can hear me well. Loud and clear.
Супер. Перш за все,
Indeed.
дякую
First of
організаторам.
all,
Це
thank you
справді
very
дуже
much
потужна, дуже
to the
масштабна ініціатива.
organizers.
Дуже
That's
дякую за
very
запрошення. Це
powerful
насправді честь
event. Thank you
для
for the
мене, для мого
invitation.
колеги приймати
It's an
участь в
honor for
якості
my colleague
спікерів
and I
стосовно
to be
мого
here
колеги
as
Миколи
speakers.
Мельнікова.
Regarding
Юрича
my
слова.
colleague
Сьогодні
Mykola
була змога
Melnik,
поспілкуватися
I
з ним
had a
буквально
chance
хвилинку по
to
телефону. Він
communicate with
передавав
him
переказував
over the
свої
phone.
поважні
He was
вітання і
saying hello to
дуже
everyone,
засмучений був,
and
що не зміг
with great
взяти
regret,
участь,
he
але
says
я
that he
сподіваюся, що
couldn't take
наступного
part in
разу
the
в нас
event. But I hope
все
next
вдасться,
time
і ми
we
будемо
will
виступати
do
вже
much better.
вдвох.
Next time it will
Сьогодні
be two
моя
of
тема,
us.
вона, ну, так,
Next
звучить
time.
доволі
My
складно,
topic
але
may
я
sound quite
буду
complex,
намагатися
but
розкласти це по
I will
таким
do my best
простим речам, щоб це було зрозуміло, що це
to
було цікаво.
dismember it
Прошу
into
організаторів,
simpler
будь ласка,
sections
поділитися
to make it
презентацією.
more interesting. Dear organizers, please share my presentation.
Дякую. Насправді в
Thank you.
фокусі сьогодні питання розвитку
Today, we're
морського
looking at the
і
development of maritime
арбітражного суду. Саме це питання
arbitration and
ключові
international
аспекти
commercial
розвитку,
court
це процедура
developments.
модернізації,
We'll look
це
at the procedures of
діджиталізація
modernization,
і адаптація до
digitalization,
міжнародних
and
стандартів.
adaptation
Можна, будь
to the
ласка, наступний
international
слайд.
standards.
Спочатку трохи introduction, якщо
Let's
можна
start with the
попередній
introduction.
слайд, не так,
Please go
не
back
так
to
швидко.
the
Трохи
previous
розкажу
slide.
про
Let me
ці дві
speak
арбітражні
about these
установи.
two
Насправді вони є
arbitration
ключовими і
institution.
провідними для
They are
України.
the
Це Міжнародний
fundamental for
комерційний
Ukraine.
арбітражний
This
суд
is
та морська
International
арбітражна комісія, які
Commercial
діють при
Arbitration Court
торгово-промисловій
and
палаті України. Що
the
стосується
commission that
Міжнародного
work
комерційного
at
арбітражного
the
суду, він функціонує в
Chamber of
Україні
Commerce
при
of Ukraine.
торгово-промисловій палаті
The court
з 92-го року, і
operates since
насправді
1992,
наразі
and
зараз він є
currently
доволі таким авторитетним
it is quite
арбітражним
well
установою
established
серед інших арбітражних
arbitration
установ в
institutions
Європі.
among
Це є
the
постійно
European
діючий
institutions,
арбітраж.
and
Арбітри
it's
цього арбітражу
continuously
це
operating
провідні юристи
arbitration,
фактично з
and
38
the
країн світу, і близько
and
половини
it
це саме
incorporates
іноземні юристи,
the
тобто
leading
командований
experts,
список,
including
який
from
пропонує
overseas,
адвокатів,
from
включає як
38
українських
countries
фахівців,
on
так
the
і
world.
іноземних фахівців, і
And
сторони мають можливість
so we have both
обрати.
Ukrainian and international experts, and
На
the
що хочу
parties
звернути
can
увагу? Близько 60-600
select
спорів кожного
about
року розглядаються в міжнародним
600
комерційним
disputes
арбітражом.
are considered by
І що
international
цікаво,
commercial
якщо подивитися
arbitration.
статистику
What is
25-го
interesting,
року,
if
десь
we look at
близько
this
80%
2025
цих
statistics,
спорів
about 80% of
це
those
спори,
disputes
які виникли
are
з
the
торговельних
disputes
контрактів, які були
emerging
укладені
from the
саме під час
commercial
війни. Тобто
contracts
про що це
signed during
свідчить?
the
Це
war.
свідчить про довіру,
What
незважаючи
does it
на
mean?
ті
It means
складні умови,
trust,
військові умови,
despite the
незважаючи на
challenging
ризики, бізнес продовжує
wartime
довіряти цій арбітражній установі, і
conditions,
український бізнес,
business
і
continues to trust
іноземний
this
бізнес,
arbitration
ну
institution, both Ukrainian and international business.
вибачте. Що свідчить про репутацію цього
And
арбітражу? Що
it
стосується морської
speaks
арбітражної
to the
комісії,
reputation of this
вона
arbitration
функціонує
court.
з
When we speak about the
94-го
arbitration
року. Вона
committee,
більш
it
нішева, вона
has been launched in
розглядає саме морські
1994.
спори
It's a
з
more
торговельного
niche
мореплавства.
one, and
Однак
it looks at
український бізнес, який залучений саме в
maritime
морегосподарський
disputes,
кодекс,
but the
довіряє
business
цьому
who
арбітражу
is a part
завдяки
of the
швидкості
maritime sector in
процедур,
Ukraine trusts
завдяки
this
ефективності
arbitration
якихось
thanks to the flexibility of the
корупційних
procedures,
моментів.
to the
Тобто він
lack of
користується
some
також
corruption
доволі популярністю.
aspects. So
Будь
it
ласка, наступний слайд.
enjoys good reputation in Ukraine.
Трохи про переваги
Now
обох
let's speak about the
арбітражних
advantages
інституцій.
of
По-перше,
these two arbitration
обидві
institutions.
арбітражних
these two arbitration institutions ensure the prompt consideration of the cases. Both arbitration have the regulation that provides for consideration of 6 months. This term can be prolonged, but statistically, about 90% of disputes are considered within this term. I guess we can all agree that it's quite prompt from that both the Arbitration Commission and the Arbitration Court made the final ruling that cannot be appealed, that can be declined in the court at the state level due to some procedural violations. Since the staff of two arbitration institutions is well coordinated, they do not usually have such groundings. The parties during 6 months get the final decision that can be enforced. Further, when we speak about the appeal of this decision, there is no appeal procedures. They do not have the institution of appeal, but only the procedure can be disputed. Statistically, only 2.5% of the decisions are submitted for the appeal according to the procedures, and only 1% is withdrawn. It attests to the high qualification of arbitration experts that the compliance is in the focus, so there is no grounds for this appeal. The cost of arbitration in comparison to other institutions is quite competitive. It's 3 to 4 times less than in other international arbitration institutions. That's another benefit of these arbitration institutions. Statistically, the decisions of international arbitration court are enforced in over 110 countries of the world. So the decisions of this arbitration is recognized not only in Ukraine but also abroad and enforced.
Далі стосовно цифровізації та оновлення
Now,
процедур.
on digitalization and revision of the procedures, both arbitration and the commission, when looking, when considering the disputes, follow the regulation. As a user who represented the interest of the parties at the arbitration and as the arbitrator, I can say that this regulation is so clear and it is very well written. If the dispute does not imply the engagement of a professional lawyer or an expert, the representatives of the parties can go through this arbitration following this regulation. The regulations of both arbitration institutions are not carved in stones, and they are reviewed every 2 or 3 years. Why is that? Both arbitration institutions are quite adaptive. They follow the trends. They do their best to adapt and introduce the innovations and trends in the legal community. They take into consideration the amendments to legislation. For example, in 2023, the regulations saw the amendments on mediation. They provided the mediation arbitration procedure or arbitration mediation arbitration mode. Now, on the communication between the parties, since around 2020, the parties have the opportunity to proceed with online communication. There used to be the snail mail communication, then now we switched to online communication. Each representative have the access to e-folders that can see all the acts adopted in the arbitration, all the documents submitted by the parties. It facilitates the procedure and also saves the time a great deal. most of the hearings are held as video conferences. It wasn't available. It used to be not available. Now it is available and it is widely used. It's the advantage not only for the parties but also for arbitrary, so that during the martial law, the overseas experts could participate online. It's a very useful and efficient tool that is really used. Looking ahead, both arbitration institutions speak openly that the key changes in 2026 is to launch the e-platform. So not only communication is going to be carried out through emails, not only will the parties have the access to the materials of the case, they will launch the e-platform that will be look at will consider the case from the submission to resolution and the filing of the case. There's a prompt information of the parties that some new documents emerged in the case. It will also ensure the opportunity to comment on the procedural documents. This will all make the participation of the parties easier. And I emphasize that it is not necessary that the parties have to engage lawyers into the arbitration process. Things are going to be much easier. This is this is the highlight of the year to come, at least in 2026, and the institutions are going to put all the effort to launch this platform. The aim is not only to facilitation the procedure, but also mainstreaming of the processes to make it easier both for the parties, but also the arbitration secretariat to be more efficient.
Що стосується адаптації до міжнародних арбітражних
When we speak about the adaptation to international arbitration standards, Ukraine used to have the legislative framework that governs the international commercial arbitration within the law we had, but this law was based on the model legislation on arbitration, and it incorporated all key trends and principles. The recognition and enforcement of the resolutions, limited interference of commercial courts, the autonomy of arbitration clauses. It was all introduced and it has all been working all the time. In May 2026, there was the pivotal event for the entire arbitration community. The law was adopted on amendments of some laws of Ukraine regarding the expansion of competencies of international arbitration. And these amendments expanded the competence, the scope of international arbitration institution. Now, Ukrainian standards are more allied with the international standards. When I say that we extended the scope of arbitration, I mean this. When we look at the previous edition of regulation, it mentioned that could consider the disputes with overseas elements. It meant that there should be some branches or HQ of some party overseas. Now, it says that the parties can agree that the object of the arbitration contract association with more than one country, it will be the actual found ground for the International Arbitration Institution to accept this case. For example, two legal entities dispute with one another if they're registered in Ukraine, but they agreed that the implementation of the contract is performed outside of Ukraine, or the scope relates to some foreign element, and this is the reason to submit this case to International Arbitration Institution. Another key amendment is that the court will be able to consider investment disputes. It's very relevant for Ukraine, given our expectations of a victory and lots of investments in Ukraine. So we build this foundation for the opportunity to consider investment disputes between any party that is a part of investment process in Ukraine and the state. These were amendments to the law, then the revision of regulations and amendments to the implementations of all of that. Of course, it takes time to develop certain practices when we speak about the expanding the scope of the disputes and the competence of arbitration. We shall see how it's going to work. But we can see very positive signs of the improvements, and it evidences that our arbitration adapts to international standards. Thank you. Thank you very much, Irina. Indeed, for 10 days, we have the new status of International Arbitration Court and Maritime Commission. I understand you very well as the arbitrator that it has happened. And given that this is the International Mediation and Law Forum, I would like to say that our esteemed mediators who work in the Ukrainian Academy of Mediation um, uh, we have this registry of mediators approved by our institutions, and we can approach them to seek the dispute resolution. Let's have a look at the questions. I saw, by the way, that our dear Jonathan Lux had to leave our meeting, but he left his contacts, his email. And should you have any questions to him, he said you could email him. So let me have a look. What are the requirements to International Arbitration Court mediators? I believe that the Presidium of the Court of the Chamber of Commerce of Ukraine now is this registry holder. So I believe we can forward this question to them. You can actually send the question to the organizers, and we will reply to you. And I believe much depends on the presidium of the Chamber of Industry and Commerce of Ukraine. But the requirements are quite transparent. We won't see any issues. There were the questions on corruption on the chat, and you mentioned corruption issues in your presentation. And the question was the following: how can the dispute in the Ukrainian court be addressed in the view of the corruption component? What's your opinion? I can only speak about arbitration, and this follow-up of my idea about the zero corruption scandals around our institutions. This is what our arbitrations are so proud of. There was no corruption scandals whatsoever for these years. Sometimes let's be honest, we can see that in the courts, but arbitration institution didn't see any. But we have to fight that in the justice system. I can share my experience, and the company's experience, we have to be utterly honest about that. We must not afraid of that. We saw the corruption manifestations from our counterparties, and we were very honest about that. We even had a publication where we compared two cases with absolutely identical circumstances, but the court rulings were very different, and we believe it was due to corruption aspect. So we decided to speak loudly about that, to counteract that, not to be complicit through being silent. And take every opportunity to fight corruption. I can see that chat also has the question to George. The question is the following. It's not about maritime disputes, but rather about our current situation. The question is the following. In case Ukrainians suffered loss of life or their families loss of life due to attack, and it affected them or their health, in your opinion, can mediation be applied here among the people who are victims of the aggression of the Russian Federation, in your opinion?
I don't really feel that I'm very qualified to answer that question. So I mean, if I can just pass, it's just it's a little bit outside of my specialty. Sorry.
Дякую, Джордж. Розумію. Я мав
Thank
задати це
you,
питання.
George. I understand that. I had to answer this question. It is really difficult, but I believe that during other sessions of this forum, where we look at these questions, we will be able to ask it. And those we will ask them from someone who protect people, safeguarding people affected by the aggression. And I also saw the hand raised. I can no longer see it. If you would like to ask the question, that's the time. Actually, I have the question. Andrea, George, Karina, please share your opinion on the following. Can we speak about the new maritime dispute resolution culture where arbitration, mediation, and other ADR function as complementing mechanisms? I would like to hear your opinion.
I'm happy to share my experience on that. I have to say there's different view. When I talk to other lawyers, there's different views on this. So there is one school of thought, the more traditional school of thought, which is that mediation is a good thing and it can help resolve disputes very efficiently and cost efficiently, and all of the good things that we know about mediation. There is, however, another school of thought, which is that mediation is basically a waste of time. That it's a good excuse for the lawyers to charge more money, to go to the room, to learn all of the secrets about the other side, because they're disclosing a lot of information and documents, and only using this as a kind of preparation to be better prepared for the arbitration. I'm just conveying what these two schools of thought are. Some lawyers think it's a more costly process, which does not often end in results. My own view is you need to look at the facts and the statistics, and I think it's quite undeniable, as Jonathan pointed out, that there's a huge amount of disputes which are settled amicably. But as I said before, it does depend on the case. And if you have, a very straightforward case where it's just simply a debt which is not paid, there might be an argument not to spend time on mediation and go directly for the decision to enforce. Again, it really depends. I think what I will say is that mediation is now widely accepted in maritime disputes as a process which needs to be seriously considered by the parties and is seriously considered by the parties as part of the overall suite of dispute resolution tools. It's increasingly used, it's favorably looked upon, but it's certainly not appropriate for every case.
Yeah, if I can follow that up, I totally agree with what George was saying, and also on the basis of my personal experience, is also depends a lot on the perception that clients have about mediation and their past experience as well, because you might inquire into clients who had really horrible experiences and in mediation, and just say, no, I don't want to go through that again because it was a huge waste of time, is a waste of legal fees and so forth. So there's various elements there that need to be considered. For sure, the nature of the question, the dispute, the quantum as well, they have a lot to play in terms of role in determining whether to go for mediation as well. And ultimately, I also think, I mean, this goes back onto my personal talk, is also depends on how you want really mediation to be effective in terms of drafting the mediation clause. And I think it goes back also to that point, in a sense that you, more often than not, you have mediation clauses which are really vaguely drafted, and they don't really convey the idea of something that, you know, parties are going to be really inclined to go for. But on the other hand, it's also true that if you draft a mediation clause which is very specific and you really render it a conditio sine qua non in terms of legal obligation, you might really put off parties from mediation altogether, for signing the mediation clause. So I think mediation is really a strange creature in when it comes to alternative dispute resolution mechanism. And also, it also goes back onto the fact that it is not legally binding either. So it is really an attempt to solve the dispute at an earlier stage compared to go to arbitration. So I think that there's so many elements that go together, and then ultimately will dictate whether parties will go for that or not. But it's without doubt can be a very efficient way to solve disputes. Really, really, absolutely. Very effective.
Можна продовжити, так?
Так, будь ласка.
May I continue, please?
Що стосується
Yeah.
моєї думки,
Regarding
досвіду,
my
насправді, на жаль,
experience,
поки що ми не
unfortunately,
зустрічали в
we
таких
haven't
застосування
met
процедури
in the
медіації. Та
maritime
тенденція,
disputes
яку ми
mediation.
маємо змогу бачити,
But
це
the
те,
trend
що
which we
сторони
are
все ж таки
observing is that the
зосереджені на
parties
врегулюванні.
are
За
more
нашою статистикою,
concentrated
десь в нас
on
наразі близько
resolution,
80
on
арбітражних спорів,
amicable
вони не
resolution. We have
завершуються
now
рішенням. Колеги
80
також про це казали. Тобто
disputes in
сторони, вони
arbitration, but
націлені
they
на
are
врегулювання.
not ended
Для
with an
того, щоб
award.
менше
So
витрачати на
the
арбітраж, для того,
parties
щоб менше
want to
витрачати часу.
have an
Для того,
amicable
щоб
resolution, not to
насправді,
spend too
напевно,
much money on
найголовніше
arbitration, not to
зберегти
spend too much
корупційні
time,
відносини і продовжувати
also
один з
to
одним
keep
працювати. Тому
their
тенденція така, що миритися,
commercial
вона є.
relations.
Що стосується
So yeah,
медіації,
there is
це
a
для нашого
trend for
суспільства, для нашого
amicable
бізнесу, це щось нове.
resolution for our
Якщо ми
community,
будемо
for our
продовжувати
business. Mediation is
популяризувати це,
something
я
new.
думаю, що
And if you
бізнес
continue to
до цього
promote it,
піде. Тому що
business
тенденція
will come to
повторюсь на
it,
те, щоб
because the trend
миритися,
again
а не
is
отримувати
to
рішення якесь фінальне, і яке ще треба
find
виконати.
a peaceful,
Дуже
amicable
дякую вам.
solution,
Питання
and
в тому,
not
що ми
to
зараз цим з вами
get an
займаємося.
award
Тобто ми
which is
займаємося популяризацією
need
медіації
to be
зараз з вами
enforced, which is
разом.
binding.
Так,
Yeah,
дійсно,
this is
якщо
exactly what we
уважно
are doing now. We
передивитися,
are
будь ласка,
promoting
зробіть
mediation now, and it's
ту
important
презентацію, яку зробив
to
Джордж, то ми можемо
see the
бачити
presentation of George.
відсотки,
Again, if you look at
наскільки
it,
зараз
we can
сторони
say the
готові до мирного
percentage,
врегулювання. І, цей
how
відсоток
many
дуже
of the
великий.
parties
Тому,
are ready
будь
for the
ласка,
amicable
звертайтеся до організаторів
resolution.
щодо отримання
So please
презентації, тому що
address the
вони
organizers to get the presentations,
показують те, що
because they
зараз
just
сторони,
reflect
особливо в морських
the
спорах, ми
trends,
бачимо, готові до
especially in
такого
the
врегулювання.
maritime
Ми
sphere,
бачимо
that the
велику
parties
кількість
are ready for
кейсів,
this
які
kind of resolution. We see
розглядає
a lot of
Лондонська
cases
асоціація
which
морських арбітрів,
are
і
being
бачимо,
treated by London
скільки
Association
завершується
of Maritime
арбітражним рішенням.
arbitrators, and we see that just a very small percentage are ending with an award.
Шановні наші учасники, будь ласка,
Dear
ми
participants,
сподіваємося на плідну
we hope
зустрічі.
that
Ми
we will
зрозуміємо, що
have a
зараз
fruitful
вже
discussion. We
вечір
understand that
понеділка,
it's already
і,
evening, Monday's
мабуть, ви
evening,
вже готові
and
святкувати
probably
свій день
you are
океану,
ready
і
to
тому
fire.
ми
You are ready
сьогодні з
to
вами
celebrate the
отримаємо
World's Day of
багато питань.
Ocean,
Є одне
and that's
питання,
why
воно
we're
не
not
зовсім
getting
так,
too many
мабуть,
questions. There is one
спробую сформувати,
question left. I
сформулювати.
will try to formulate it.
Написано приблизно, як узгоджуються етичні питання
How
арбітражних процедур з медіацією? Як
how to
узгоджуються
put
етичні
the
питання арбітражних
ethical
процедур з
issues of
медіацією?
arbitration
Ну, або,
procedures
мабуть, давайте
with
просто
mediation
обговоримо
accordingly.
етичні питання
Let's just talk about the
арбітражі та
ethical
при
aspect in
застосуванні
arbitration
медіації. У кого яка
when
думка
mediation is being
або поділіться
implemented.
досвідом.
If you have an opinion or an experience.
Про що саме йдеться? Які саме етичні
What are we
стандарти
talking about?
застосовуються
Which
в
ethical standards are being implemented in both mediation and arbitration?
Мабуть, про них вже згадували, тому що
Maybe we have mentioned them
що
already.
може арбітр, да, що
What
не може
can
арбітр, що
what
може медіатор,
can
що не може медіатор. Будь
arbitrator
ласка, Джош.
what is he allowed, what is he not allowed to do, what he may do or not may do. George, the floor is yours.
Yeah, sure. Well, very briefly, I would say that we must always remember that the overarching obligation of an arbitrator and of the court, the same, is to dispense justice. So this comes above everything else. So of course we need to do it consistent with the law and consistent with the evidence and the party submissions, but no arbitrator that I know is going to issue an award which is blatantly and completely unjust. That's inconsistent with the overall obligation of a tribunal, which is, again, above all else, to dispense justice, the same as the court. In mediation, there is no such obligation. So, in fact, the parties could agree something which is completely unethical in mediation, and their agreement would be binding, and there's no authority above them to not allow this agreement. The parties are free to agree whatever they want to agree, providing, of course, that it's lawful, but it may be still unethical. There's no bar there, as far as I'm aware. So counterintuitively, we might find that there's more scope for unethical agreements in mediation than there is in arbitration. But to be honest, at the commercial level, where I operate, I don't think ethics is really coming into play. They're very rarely, it's not a factor. These are commercial parties, they have commercial disputes, and I've very rarely come across any kind of question of ethics.
Дякую. Ну, мабуть, тому що це питання від адвокатів.
Probably because this is a
тому що у нас
question
є
from
правила
lawyers,
адвокатської
because
етики,
we
ми
have
маємо завжди
rules for the
говорити
lawyers,
в справі,
attorneys'
коли ви
ethics
просто
when
йдете
you
з
are in the
вулиці, тобто
case,
ви у будь-якому
or
випадку
when you are
адвокат, і
walking
ви
on the street, you are
завжди
still an
маєте
attorney,
відповідати цьому
and you
стандарту
always
та
have
відповідати
to be
правилам
in
адвокатської
accordance with
етики,
the
які
standard,
запроваджені в вашій державі.
with this
Мабуть, питання,
lawyers'
вимоги від
ethics
адвокатів, які
stipulated by your state.
цікавляться
So
саме
that's
цим,
why
як це
the
відбувається в
attorneys, they
арбітражі та
put
в судових
such
медіаціях.
questions.
Мабуть, хтось бажає доповнити.
Probably
з колег,
someone
будь ласка.
else wants to ask or add.
Так, ну бачу, що з
I
нами
see
ще
that
залишилося 230 людей.
we have
це здорово,
230 persons with us,
тому що на початку було 305,
and it's
зараз
great.
230.
We had
Я дуже всім
305
учасникам
at the
дякую.
beginning, now
Розуміючи,
it's
що він тільки
230.
перший день великого
I'm
марафону,
grateful to
який
all the
називається
participants.
10-й
Today
міжнародний
is the
форум
first
медіації
day
та
of our
у нас
marathon of
остання
the 10th
сесія, остання панель.
International
Шановні
Forum
спікери,
Mediation and law. This is our last panel. Dear speakers, George, Jonathan, Andrea, Karina, I'm very grateful for you for coming to us, for supporting us with this panel dedicated to the arbitration and mediation hybrid mechanism of maritime disputes resolution. It went all great, to my opinion. And thank you for your presentations. Thank you for your time. We know that your time is extremely expensive. And again, we understand it and we respect it. If the organizers have any questions to us, we are ready to answer. Tell us, please, if we are able to, if we are allowed to finish our panel. The organizers are only grateful to you for this interesting discussion, for these different perspectives on the maritime disputes resolution. It was a pleasure to spend this evening time with you to reflect on what the modern methods, options of dispute resolution are, that hybrid is practically becoming a trend and a norm. Thank you, Louisa. Thank you for your invitation, Ukrainian Academy of Mediation, for conducting such serious and exciting events. I don't know who works for such a long time, involving so many cool specialists from Ukraine and from all over the world to promote mediation in Ukraine and abroad. And I hope that with our effort, mediation will be even more spread in Ukraine.